We're very honored indeed to have such a distinguished symposium. I would venture to think that this is one of the most distinguished symposiums that has been assembled at any one time. Certainly I've never been at an event where we've been blessed with such great talent. So it's my pleasure and great honor indeed to turn this event over to Chief Justice Morden, who will introduce the symposium members.
Thank you, Mr. McDonald. It's my pleasure in turn to introduce the members of this panel. On my right, immediate right, Madam Justice Claire Leroux-Dubé of the Supreme Court of Canada. On my immediate left, Madam Justice Beverley McLachlin of the Supreme Court of Canada. To the right of Madam Justice Leroux-Dubé, Mr. Justice Coulter Osborne of the Ontario Court of Appeal. And to the left of Madam Justice McLachlin, Mr. Justice Thomas Granger, Regional Senior Justice, Southwestern Region, Ontario Court of Justice, General Division. And on my far right, Mr. Justice George Walsh, Ontario Court, General Division, and the head of the Family Law Division in Toronto for many years. Now, this panel is concerned with the subject of presentation in family law cases. There are, of course, a wide range of potential ways in which a case may be presented. The most effective will depend on the facts and the issues which arise or may arise from these facts. On a general plane, it has been said that the function of advocacy is twofold. One, to make the court want to decide the case in your favor, and two, to show it how to do so. That is, to give it the factual and legal underpinning for the sought-for decision. Now, you may ask, why do we have a panel of judges here on this subject? I'm not certain, but I have a potential reply in the form of a quotation from a lecture given by the great American advocate John W. Davis, who said, "Supposing fish had the gift of speech, who would listen to a fisherman's weary discourse on fly casting, the shape and color of the fly, the size of the tackle, the length of the line, the merit of different rod makers, and all the other tiresome stuff that fishermen talk about, if the fish himself or herself could be induced to give his or her views on the most effective methods of approach?"
With a fish.
For after all, it is the fish that the angler is after, and all his or her recondite learning is but the hopeful means to that end. Now, applying these principles to this panel, you can see that we have three different species of fish. We have two Supreme Court of Canada judges, one provincial appellate court judge, and two trial judges. And as you know, these fish swim in different waters. During the course of this panel discussion, we may well glean some insight into the different angling strategies and techniques with which to approach each species. Now, to start the discussion, I would ask Madam Justice Leroux-Dubé for any general comments she may have on the subject at hand.
I'll make no comment about the fish.
Okay.
I suppose I'm in the category of small fish. If I understand well, some portion of your sessions discuss moje. I call it moje because it's a Polish name and they say it's moje. Uh, well, I guess I was very naive. I thought Moji had settled everything. But what has transpired seems that it had started everything. For those who might feel disheartened by this, I offer the view that this is a very healthy turn of events, and this is how legal thinking and legal theories advance. But I have a few caveats before answering all the questions, which I won't answer all for sure. I'm among those of the Supreme Court of Canada, and I'm not alone, but it's not unanimous as usual. I hold the view that we should not explain our judgments. So I won't. I'm sure that all the professors that you had have already done that job very well. I'm prepared, however, to comment on the comments with proper judicial restraint, of course. My law clerk got out a series of comments. Some I like, some I don't. One caveat, however, since the Globe and Mail has discovered different views from the bench, the thinker and the intuitive may have different answers to the same question. And that is quite healthy, too. A word of warning also, do not take my views too seriously. They might bring you to the minority where I am always. So, perhaps with these restrictions, the questions can be answered.
I was kind of hoping you'd say more tn that, but we'll...
I'm restricting myself for the moment.
A general question. If you could tell counsel what issues to develop in their presentations and what to leave alone, what would you tell them, Madam Justice McLachlin?
Well, just before I try to answer that question, I can't resist a comment. Chief Justice Morden indicated that the reason we have so many judges is justified on the angling theory. But when I asked him why we had so many judges from the Supreme Court here today, he gave me another theory. It's known as the Big Bang theory. He said, I agree you don't rule on these things very often, but when you do, it's a real big bang. In any event, to try to return to the question, what would we like to see, what would I like to see personally, I can only speak for myself, in presentations in family law cases. I won't deal with the trial levels where I did sit, and I did much family law when I was a trial judge. At the level of the Supreme Court of Canada, I think by and large we get very good presentations. If there is one thing that has bothered me on occasion, and this applies in other cases as well, but it has caused us problems, I believe, in family law cases from time to time. It is the fact that counsel understandably may not have thought through their case completely in the early stages when they were putting evidence in and so on and so forth. And so we may end up with a very sympathetic case in which it emerges, for example, that the issue is unjust enrichment, but the case was presented on a different basis below, or the right questions weren't asked. I'm not talking necessarily about having to get an expert at every trial, but simply the need, I think, to, when you start off with a case, to think about it and think about what legal doctrines could be involved in it, what areas it touches, and think about the fact that the law might grow. You might be an instrument in advancing the growth of the law, as my colleague has suggested Moja does. What happens when we get a case that hasn't been properly thought through at the lower levels? Comes to us, and counsel suddenly have all sorts of great arguments, and we might like to give effect to them, but we're not always able to do it. or if we do it, we're having to strain and stretch, and it doesn't make perhaps for the best jurisprudence. So I would ask you to, even if you think it's a fairly pedestrian, humble case, and some of them are, Moja was a very humble case at the beginning, and this isn't a case that I would put in that category, by the way, do think it through and try and think of the different areas of the law that may be involved and the different arguments which might be advanced even at a higher level. On that basis also, when cases come to us in the family area, it's because they involve issues of national importance. So look at the case from the perspective of a national issue. It's very important to your client, of course, but it has become, by the time it reaches us, a national issue. And the judges in the Supreme Court of Canada are going to be looking not only at the result in your case, whether that will be just or not, but how what they say, what they do may impact on the law throughout the country. And so it's important, even if you come from British Columbia, that you have some idea perhaps of what some of the problems are in Ontario or what some of the comparative legislation is like, that you have looked at it in a broad respect. And final comment is, I think it was former Chief Justice Laskin who said the law is a seamless web. If you come to the Supreme Court of Canada, for example, on an unjust enrichment case, you may get a question that is not based on a family case. You can't content yourself with simply steeping yourself in the jurisprudence that's has dealt with couples who are splitting. You're going to have to examine the general jurisprudence of the law of constructive trust and so on and so forth. And sometimes, not often as I say, occasionally we've had counsel who were just unable to help us relate what they were asking for on the family case to a wider perspective of the law. So I offer those comments for what they're worth in terms of advocacy at the Supreme Court of Canada.
Thank you. Mr. Justice Granger, do you have any comments on the practical recurring issues in the presentation of cases at trial relating to judicial notice, and how far does that concept or rule extend?
Right. First of all, let me just tell you what a frightening experience this is for me to be here today. In Ontario, usually I can decide a case, and I have about 24 months to bask in the glory of my decision. Before it's overruled, although sometimes in my cases they overrule them in other cases. In any event, it's terribly frightening to be here to know you can be immediately overruled. But let me talk, if I might, just for a moment about judicial notice. It concerns me just a little bit, and perhaps it's because I don't understand what was said in the Moog case. It seemed, in that case, well, we do things a little differently down the Southwest, you see. We don't have any of these big cases I've heard about all morning. I mean, people can barely pay the bills, let alone have any extra money for compensatory support. In any event, in that case, it suggested that perhaps judges should be taking judicial notice of social scientist studies in order to move the litigation process along. And one can understand that because it would be much cheaper for people. I mean, that's one of the great problems today, is the cost of matrimonial litigation. It really has got quite out of hand, I think, for the average citizen. But in that case, they talk about taking judicial notice of studies. I then read Elliott, and over lunch I realized that I'd probably misinterpreted Elliott. Associate Chief Justice Morden told me I probably had anyhow, but and he's pretty good authority to in any event. I thought what he said in there that studies of social scientists were of limited value in deciding economic laws. He may not have said that. I may have misinterpreted the case. I get concerned at the trial level about taking judicial notice of studies done by social scientists. And I noticed yesterday in the Ontario Lawyers Weekly, there's an article on Professor Vidmar, who was recently at the, formerly at Western, now teaches at the law school at Duke University in North Carolina. And he argues that it's very risky to start taking judicial notice of studies of social scientists because we as judges perhaps do not understand their language. And also, the difficulty is that the social science field seems to be changing every week. We've heard for a long time that young children never lie. Now there's a whole new body of evidence that says that that's not right. I think that it may, I understand how you may use it on the support side, but when you push that judicial notice into custody matters, I get very concerned. You have, and it becomes very critical in this province when you only have one assessor. That assessor comes and says, well, I base my whole assessment on certain studies. What if those studies are flawed? That's what concerns me about relying on social studies that have been done. Having said that, I probably should say goodbye and duck out the door because I know I'm in big trouble.
Well, perhaps I could respond to that.
She absolutely undertook at lunch she wasn't going to talk about any of this, and here we go. I knew I could get you to talk.
Judicial notice, of course, Tom, all of us know, it's a very old notion, and the court is continually referring to that as recently as in Jones in 1986, where Justice Laforêt wrote, a court must be taken to have general knowledge of our history, of our values, and to know at least the broad design and workings of our society. We are not concerned with particular facts. No proof is required to show the importance of education in our society and the significance in government. In Moji, we were talking about statistics. Statistics that show we don't live in 1800. We live in 1993, where women are poor, where children are poor. You read that in the papers. I don't think that it is very dangerous to me for judges to take judicial notice of those facts. And I think that a judgment speaks to a lot of interveners, including judges. And I remember in my law practice 100 years ago that judges were not aware how a quart of milk was costing. And perhaps today they need to be remembered that to bring up children costs some money. So I think that in that sense, judicial notice is very important, and as Laforêt said in Jones, and then relying on Statistics Canada. I think judges perhaps just bringing their attention to Statistics Canada said this and that. I don't think that's very controversial. I don't know that expert would dispute Statistics Canada, and that's what Moji relies mostly on. And apart from that, I think there are two rules. The rule of construction of normal statutes say you cannot interpret a statute in a vacuum. That's the first rule, and that has always been applied. The second rule is in constitutional interpretation, that the context is very important. So how do you take count of the context if there is no judicial notice? Expertise, as we said, and Beverley said in Young also, is not necessary in every case. I think there is a common sense approach to say that judicial notice should be taken of the current facts of life. And in that sense, I'm sure Tom doesn't disagree. He worries about this literature, perhaps, that is more novel, like feminist literature, perhaps. Before that, we relied on main one, so now we've changed. So anyway, that was my comment. It doesn't frighten me, but you cannot go overboard. You have to use your common sense all the time.
Mr. Justice Walsh, is there anything that you would like to say on judicial notice or the related subject of the use of expert evidence, or on anything that's been said up until this point?
Your turn will come.
I kind of feel like a fish out of water here.
That's good.
I agree with everything that's said. I wonder if I have an opening, I wonder if I could talk about my pet peeve. And I think that what's happened to us today is that our trials are too long and they're too unfocused. And I think nothing replaces proper preparation of a case. And the ones that I've seen lately, I think, know the questions you're going to ask. Make sure your client knows the questions that you're going to ask. And then bring out the evidence clearly and concisely, and don't spend 3 days flogging the obvious. One of my real problems that I've been facing lately is make certain your financial statements are accurate as possible the first time around. I have great difficulty accepting the credibility of a wife or a husband who changes the values and the figures in every new financial statement that I read. Financial statements are sworn, and if they are sloppily prepared, in my view, they reflect not only on your client, but more particularly on the lawyer who allowed a sloppy financial statement to be prepared. Now they were talking about what issues to develop. Now I'm on a roll, I'm going to have a shot at this. I think when you're at trial, stay focused. What issues are essential to your case? Make sure you cover those issues. Don't get carried away with a lot of issues of marginal relevance. Watch your numbers. The Family Law Act is an act of numbers. You're playing with values, and the numbers have to add up. The judge has to add them up at the end. So when you're dealing with all of the various items, remember they're a number. Give the judge the backing as to whether he accepts that number or he doesn't. Judges can't all of a sudden magically give you the result that you want if there's nothing behind the numbers that you want them to accept. What should you avoid? Very simply, conduct. It's going to get in anyway, so whether you try and sneak it in or whether you try and keep it out, the judge is going to find out about it. Thank you.
That was sort of an abrupt end. I thought you were on a roll.
I was afraid to go any further.
But we can come back, can we?
You indeed can.
Mr. Justice Osborne, have you noted any changes in the presentations in the cases following Moji?
Well, I've noticed that nobody can agree on how to pronounce the name of that case.
Wait, I'm sorry, we have an authoritative pronunciation.
Now I know. The law clerk who helped me and who is here did a quick computer search, and at the trial level, Moji has been referred to on a number of occasions, but it has typically been in the context of time-limited support orders, submissions which, in my reading, have been accepted by the trial judge who concluded that time-limited support order in the particular case was not appropriate and resorted to Moji as support for that. The further two areas or issues that were dealt with under the general umbrella of MOGI were related to the clean break model of support and an undue emphasis on a self-sufficiency model. All of those are supportable by resort to passages of both Justice Leroux-Dubé and McLachlin in MOGI. Apart from that, it seems to me that there is a therapeutic benefit, if not a direct benefit, from the reference in MOGI to judicial notice. I don't know how judges are actually going to interpret those passages, which are relatively brief. I hope it works to dilute the enthusiasm some of you may have for calling an expert, particularly on economic issues, in every case. Family law, as has been pointed out, family law is expensive enough now. We don't need to convert it into a trial by experts. The discount rate for the calculation of future losses, if calculated on a lump sum basis, something that has been addressed in Elliott, is fixed. I would hope that as cases move through the courts, economic issues in particular are resolved by agreement without spending horrendous sums on economists and actuaries, notwithstanding the fact that due to changes in the personal injury litigation, they may soon be underemployed.
Since you've raised the question of clean break, perhaps I just could interject this, that MOGI, of course, is not PELEC. And PELEC will have its day in court shortly, since leave was given in Masters versus Masters on December 17, 1992. Apparently, it's a case from BC, and there is a Quebec case on the same issue that is in the process of being decided whether or not we'll grant leave. What I want to stress also that perhaps hasn't been realized that MOGI is the direct heir of Messier de Lage, which seemed to have gathered dust in this, along the way. People were trying to use the minority, the dissent, but the majority, in that case, if you remember, it is a woman who had already gone back to school, had acquired some skills and everything, but couldn't find a job. And the court said that support would continue. So in the issue of self-sufficiency, the court didn't stay there. So I think that you have to realize that it's in the line of Messier de Lage, and MOGI is what Professor Payne has said all along, because Professor Julian Payne is probably the author of the Divorce Act. At least he did the Law Reform Commission one. He has been saying that all along. So to me, it's difficult to see what novelty there is in it. I would love to be a genius and create things, but I think I did not, or we did not. It is a unanimous opinion of the court. So you have to look at it in the context of what happened before. And I just wanted to say it's not PELEC anyway, and we're going to deal with PELEC, which means separation agreements that are final upon the final divorce, and decide whether or not under the new Divorce Act, what are the rules, if they are new or not.
John, could I just jump in with 2 minutes?
I wish you would, and take as long as you want. Tom.
I forgot to talk in talking about expert witnesses is the use of the assessor in custody cases. There are some very good remarks on it in Young against Young. I was thinking when I brought Young against Young, I know how you lawyers like to file case briefs. Well, you go bankrupt if you put the whole of Young in your case brief. I had enough trouble even lifting it to bring it here. But there are some really good comments in there on the limited use of assessors, that perhaps assessors are not needed in every single custody case. The suggestion that perhaps the parents know just as much as the assessors do about what's in the best interests of the child. It seems to me, certainly in the region I sit in, that the day of having an assessment in every custody case is long gone, that you now have to justify why there should be an assessment, especially when assessments are costing between $3,000 and $6,000. Most people just can't afford them, and legal aid may not be able to afford them in the future. The second point I want to talk about, Justice Walsh touched on it, is this issue of conduct. What do you do as trial lawyers when you want to get in conduct? Because I know you're going to be faced by the trial judge saying, but I thought that's what the act said we weren't supposed to talk about. And you've got to get it in if you're going to talk about economic disadvantage. And you get it in under property, maybe under an unconscionable division of the values. You may be able to slip it in there. So my view is that conduct's not dead, and you may well have to adduce that evidence, and it's certainly going to lengthen trials. I mean, I think that you're entitled to call evidence of a spouse who says, I did more than my fair share of all the work in the family unit. I not only worked downtown 8 hours a day, I came home and helped around the house. Now, I think that's relevant evidence.
That's good conduct, though, Tom. What I think we're really talking about is bad conduct, isn't it?
No, there's an inference that the other spouse probably wasn't as good as should have been.
Right. Tom's been trying for years, even as a lawyer, to reintroduce conduct in family law litigation. He sees an opening.
He's not the only one, because some authors like Leonard Weissman has said that eliminating conduct from the Divorce Act was a tragedy for women. Well, I don't know if that is true or not. I'm not making any comment on that, but I know that there has been that aspect of the literature that says that. So, but we're not talking. I don't think that either Tom or you, Coulter, are talking about conduct in the sense that she was sloppy, she was... no, I think we're talking in terms of what kind of life they lived. And if I remember well, of my time with the Law Reform Commission of Quebec and my association with the Law Reform Commission of Canada, what was the purpose of the Divorce Act, certainly at one point, and perhaps it's still there, that to assess the people as they lived. They live in a certain standard, if they lived in that fashion and so on, to continue on kind of the type of agreement they had between each other. So I think that when you speak of conduct, I don't know what you feel about that, Bev.
Well, I think there's a lot of misunderstanding about what we mean about conduct in the course of a matrimonial dispute. Clearly, it seems to me that insofar as contribution is relevant, and it is under the Divorce Act, that is related to conduct. But I think what we must try to avoid is what I call the catharsis theory of trial. And I know as a trial judge, very junior, much too meek to say, don't you think this has gone on long enough? I sometimes sat through weeks of trial where we started at, usually the first 6 weeks of the marriage were okay. Occasionally there was some problems on the honeymoon. And then... And then we worked our way through the first pregnancy, the first birth, the child. We went through the whole thing day by day. I knew these. In one case, I had 3 folders of the 3 houses the couple had lived in, and all the rooms and how they'd been decorated at the different phases, because this was the wife's contribution. And it was a great contribution, but I really could have made a decision in her favor without the color schemes. And one becomes more and more restive. Not that I think I've always believed that family actions, matrimonial actions are the most important of the court's business. And so what I am not amongst what I'm saying is not meant to suggest that we should take less time with them than we spend on commercial matters. I don't believe that. But I think that we should allocate the resources that we have very well, and also the parties' resources. And I'm sure that other people have had the same experience as I have had, watching a couple literally fight away their modest assets. And it grieves the judge who's presiding over all this and who wonders, is this the best thing to do? So I think that while conduct is important, if there's some way to give the court a picture without going into a day-to-day diarized saga of everything that happened, this is advisable, and I think it can be done. I think judges very quickly get a picture of where the general rights and responsibilities lay, who was doing what, and so on, without going into all the details, without going into every story of abuse, and most of these cases have many fights, many abusive stories, etc., etc. So this requires some restraint. It also requires some discipline on the part of counsel, because often the parties want to tell somebody, and they want to tell somebody who's sitting up there on the bench just what a terrible person the other party is, what they've done, what they've been through, etc. And all that's valid, but it really deflects us from the purpose of the trial, which is to try to get to the truth and get to the right remedy. And sometimes, unfortunately, it just has the effect of exacerbating the problems between the couple, who may have to still have some sort of a life together because they have common children and so on, and even though they're living separately. And when they hear each other telling the judge these horrible things over and over again, they get so upset that they can never bring themselves to see their former spouse as a decent person with whom they could possibly have anything to say or cooperate. So it can be a very negative thing. So I only say that I think conduct obviously is important, but we have to be careful about not going overboard. On another unrelated matter, on statistics, I think Justice Walsh said you have to make sure you get your facts and figures right. We had a case in our court where the columns were wrong, and it wasn't a family case, but it was. It's a very well-known case, and there were statistics presented at our level, and they were in the factum. And 6-8 months later, counsel appeared before us in another case, and they said, oh, by the way, in case A, you got that all wrong. And the judge who wrote the judgment sort of, looked up and said, well, what do you mean? And I took it right from the factum. And he said, and counsel blithely said, oh, yes, we know, but we've inquired of counsel, and he got the columns mixed up. And so the figures actually told a different story completely than the conclusion the judge had drawn. So this is why courts get a little bit anxious sometimes about over-reliance. So I beg you, if you're going to use statistical evidence, and it can be useful, be very careful about how we rely on you. Sometimes we not only read your factums, but we put parts of them in our judgments, and it can be embarrassing if they turn out to not be entirely accurate.
Perhaps something that comes out from my law practice and may solve the problem of people wanting to say it to the judge. I used to ask my clients to write down their life story. It was very good emotionally for them, didn't cost them a cent. I never read it. But God, did they feel good. So you don't have to repeat it with a judge. You've already said that to the lawyer. So just less facetiously, perhaps, it may not be bad in thinking in terms of statements of fact. We do that. They do that in criminal law. So why wouldn't you say state facts that are not contested? We've lived 20 years together. We've had 3 children. Things that can be put. Even my wife stayed at home and I work, and we were. So there's a lot of things that can be eliminated by a statement of facts, but people don't seem to think about it in family law and leave only the contested aspects. And so this is a more practical thing that you can do to help. And also another consideration that has come more and more in the open is that people cannot afford lawyers anymore in family law. And you have to think about it. In New York, for example, the question came up, and the Chief Justice, Judge Judith Kaye, now has made rules that lawyers cannot seize the property of their clients for their bill. They have a whole ethics rules to follow. So in order not to attract those from the legislature, perhaps you can think in terms of reducing the cost. And people are not, generally, the fights are for rich people, and they can use all the expertise and everything, but generally people are not rich and are not able to sustain the cost of this litigation. And they use all their resources in order to do that, and the children need to eat. So think about this. I mean, it's very nice to earn a good living. As a matter of fact, it's only since the Divorce Act that the profession has become extremely regarded as law. In my time, it was regarded as nothing. So now that it's profitable, it's not a mandate to go overboard. And you have to. And another aspect that I read in the New York Times is that billable hours are out in New York now. The companies don't, even the companies. I'm not talking about small people, but. The companies don't afford it. There's a lot of bargaining. They will charge so much for a case. So you have to think in family law particularly about this extremely serious problem, I think, that people cannot use the courts. I mean, perhaps it's good if they can use other methods of solving their problems like mediation and arbitration and name it, which are good. The diversification from the courts, which probably will not be able to handle the load at one time or the other, but still, I think the courts are always the last resort. So you have to think in those terms.
If you're thinking that I'm going to make some sort of a ruling that there'll be no more billable hours, forget it. I won't do it.
Well, George, perhaps you could just pick up on, give us a little empirical evidence yourself, or maybe Tom Granger. To what extent now are parties giving a general picture of the marriage as opposed to a day-to-day rendition of the whole history of the marriage? Is there any change in the modes of presentation along those lines? George?
Well, what's happening in the great world out there? I don't think really that the case has been out there long enough for me to see any substantial change in the way in which trials are conducted in that manner. I think it's frightened an awful lot of lawyers, and because of some of the things that were said in the judgment, that they're afraid if they don't bring certain facts out, that their clients are going to turn on them and that they're going to be sued because they haven't dealt with some of the matters in the manner in which they were set out in the judgment. I think...
What, you're referring to Moji?
Yeah, I am, yeah.
What sort of issues are
Oh, I think
being
that you have to deal with each individual item that's set out there, and unless you specifically deal with each one of those items, then you're in some considerable trouble. I think that the overall impression that I get from what I hear is that most people feel that as a result of Moji, that all judges should be thinking in increased amounts, and that that is the stress that is being placed on the cases that I hear, and particularly on the motions that I hear, that you're far too low, that you have to take into consideration that judgment and particularly the statements in there that judges are a little bit parsimonious, and that you should be moving the amounts up. I think overall that the effect of Moji has been that it's had a realization by all, I think, family law lawyers that we have to rethink family law a little bit, that were we really giving the family a fair shake? There were things that perhaps some of us had forgotten, some of us that we should have. It's refocused, I think, a lot of our thinking, and I think overall that it will have an ameliorating effect. I think if you try and dissect it and then slice it again and then dice it, as some are trying to do, I think you're missing the point. I think it, as Justice LaRue-Dubé has said, that it was a unanimous decision of the court, and it stands for the proposition that she put before us. And I think if we remember that, then I think that we've got it in proper context, and we'll move ahead with family law.
Tom?
I suspect that we're starting to see conduct creep back into support applications. And it's also creeping into property. I think really what we're seeing is that the law of property and the law of support merging. I suppose what concerns me just a bit is that what it does when you let conduct back in, you let judges have a very wide discretion. It was always my view that discretion is what defeated the Family Law Act. Because what then happens is that lawyers wait to see who the judge is. And what we do if we're scheduling judges is try and fool you, that we won't let you know who the judge is so that you'll settle your case. But if judicial discretion sort of rises up again and becomes very important, then from the practitioner's standpoint, it's going to be very important to know who the judge is and start tracking judges and the way they decide cases. And that was true many years ago. Now, the problem with letting conduct back in is that it will lengthen trials. We are not seeing in the Southwest region any increase in matrimonial trials. As a matter of fact, what we're seeing is probably a decrease. No one can afford to go to trial these days, but the problem is the client's being bankrupted before they get to trial. I don't know if we see fewer trials because people run out of money. What we do, I suspect, see is that as soon as the client has no more money, the lawyers become very reasonable, and all of a sudden we better settle this thing. But it's a great concern to me that the time between the issuance of the statement of claim and trial, if it's 2 to 3 years, then there'll be all sorts of motions. And that's what's costing all the money today, those interlocutory proceedings. If we could develop a system that between the issuance of the writ and the trial, it was 6 months, maybe that'll never happen, but if it was 6 months, then interlocutory matters wouldn't be so important, and we could move right along, and all people's money wouldn't be lost. They could have their trials, and probably lawyers wouldn't be criticized as much as they are. I mean, I have a feeling from what I see in the odd case that somehow where the legal fees get revealed, that there's been a dramatic increase in legal fees over the last 5 years. I suspect it's because lawyers now docket their time, and it just goes into a computer which spits out a bill that says that the legal fees are $10,000. But it's not unusual in the cases I see to see a case where a family has a house, a modest house, one pension, and before they get to trial, one of those spouses has been billed $15,000, maybe both of them. They can't afford that. I don't blame the lawyers because you've got staff to pay, and if you're in a big firm, you've got to go to meetings and justify where your hours are going. This is a problem, and it's a challenge, I think, of all of us to develop a system that gets these matters dealt with much faster. Sorry it takes so long.
Sorry, Tom, but following up on what you said, I think that we've sort of come to realize in Toronto that there's a great deal in that, and I think we're now working towards, within the short period, I hope, of putting a plan in place in the Toronto region, where we will probably take most of the cases into a case management system, whereby a judge will become seized of a case and at what stage we're working on, and we hope that will ameliorate the situation. Costs have escalated, but I can remember when newspapers used to cost 3 cents, too. And I think that I don't blame lawyers for charging large fees. I don't think you're greedy. Probably some are, but the majority of the time it takes up a lot of time. Family law is different than all other fields. You've got husbands, wives, fathers, mothers, children. They all have a real interest. It's not like you're dealing with a nameless or faceless corporation. They want to phone you. They want to know how their case is coming along. They pick up the phone. They want to speak to you 5 times a day, 6 times a day. They don't mind phoning you at 10:30 at night. They don't mind getting you out of bed at 6:30 in the morning. And we have to realize that. And I suppose our real danger is that unless we self-administer ourselves in some way, that on the far distant horizon out there, I see the situation arising where the costs have gotten so high that we're going to end up with a mandatory ADR system of some kind, and probably not very far behind that, we're going to end up with mandatory binding arbitration, and courts will be completely out of family law. And I don't think any real family law lawyer wants to see that happen. But there we are.
Thanks, George. Madam Justice Bay, do you have anything you'd like to say on the subject of judicial discretion in family law?
Well, Moji talked about it, and particularly, I think Young, the most recent decision on on custody and access, because the legislation was attacked on the basis that it gave judges too much discretion, and we said that that didn't render that legislation unconstitutional. But there are some movements I can see, particularly in the children's field, to have guidelines like they have in the States. For example, in some, there is a specialist here from Connecticut that could correct me if I'm not correct, but I've known that in some jurisdictions, the judge has to consider as the first criteria joint custody, and then goes down the line 10 things. So to me, I'm totally opposed to that. I am for judicial discretion in family law more than in any other area of the law, and just as in sentencing. Otherwise, the judge is in a straitjacket, and the family law situation, children's situation, need a lot of possibility and flexibility on the part of the judge to adapt the solution to the particular cases. I understand that the Minister of Justice, the Department of Justice, Federal Department of Justice is looking at guidelines for custody and access. My view is that you confound 2 things: discretion and nomination of judges. If judges are well nominated, the discretion will never be a problem. I know of a judge in Quebec, Judge Mera, who is a kind of a saint and adoration for me. Nobody ever questioned his discretion. He used it judicially and judiciously. So I think that you have to go back to this notion of nominating good judges. And if you do, discretion will never be a problem. But And I think that our court has said many times that discretion was a feature of constitutionality. In Baer, for example, Justice Laforest said, the existence of the discretion conferred by the statutory provision does not offend principles of fundamental justice. And then in Barron, which is a recent decision of our court in 1993, the presence of residential discretion of a judge may itself be a constitutional requirement in some instances in order that there be a means of balancing the competing rights and interests of the individual and the state. So I think we shouldn't be afraid of judicial discretion, but we should be much afraid of nomination of judges. And speaking about that subject, this is actually on the board because the media, the academics, everybody has raised that possibility of having more scrutiny for nomination of judges. And I think that the new government has seemed to indicate that they wanted to do something about that. So perhaps it's a more fundamental question than judicial discretion. Well existing exercised, there's really no problem. You'd be the first to be, I would say, mad at the fact that you would be put in a straitjacket because the judicial discretion would be curtailed by those very stern guidelines. So I warn you about that. Because the profession, of course, likes very clear rule. It likes to have precise points and everything. Well, family law is not that kind of legislation. It has to be very flexible. I think in Moji we said that there were no neat compartments, there were no precise rules, and in my view, it should stay like that.
I wonder if I could add just one comment on discretion. I agree with my colleagues' comments, but I think that discretion is sometimes confused with a subjective impression. And I think judicial discretion is a very special thing. It involves an exercise in objectivity. In other words, the judge is not simply imposing his or her cultural views or whatever, his or her lifestyle views or values in making a custody decision. The good judge, the judge who is properly named and trained and understands the judicial process, will realize that he or she has to strive for a level of objectivity to make a decision which is discretionary, but which is not simply a substitution of his or her personal values for those of one litigant or the other. And I think particularly in a multicultural society such as we have, judges have to be very careful to, if they've got a couple between them with differing beliefs or cultural backgrounds and so on, to strive for that level of objectivity and look at it in that way as they're exercising their discretion. And if they do so, then I think you won't have many of the dangers that are sometimes associated with the word discretion, which implies palpatory justice, willy-nilly, ruleless exercise of power.
Thank you. Just mentioned now, contrary or not consistent with the instructions that Mr. McDonald gave the panel. Before we finish, I think we'll take one or two questions from the floor. I mention that now so you can think up some good ones, and I'll rule on the propriety of the question, but we'll continue along. Getting back into the realm of forensic persuasion, Mr. Justice Osborne, is there anything further that you would like to say about techniques of presentation?
Well, I think it's important to, in family law matters, to not to divorce them from other litigation in terms of assessing what your undertaking as counsel is. That is to persuade and establish a record for the judge upon which the judge can determine the issues that have to be dealt with. I always thought it, and still think it is important in most matters, including family law matters, to make an opening statement. I found as a trial judge very often in family law matters, nothing happened except the spouse who was the plaintiff or petitioner would be marched into the witness box and the trial would begin. The trial judge will likely have read the record and know nothing more about the case than that. Thus, I suggest it is wise, notwithstanding that some less than saintly judges may encourage you not to say very much in opening, to indicate to the judge that a brief opening statement will, in the end result, save time. I also always thought it was beneficial in family law matters in particular to give the judge a chronology. A piece of paper that's headed chronology, which would set out the critical dates when things happened. The chronology can also be used as a prop for examining witnesses, and in most cases, there will be no objection to it. It's a very rare case when the date of separation, for example, is in issue. If it is, obviously, that has to be indicated on a chronology. But if you do that, you get the trial judge and even judges on an appeal on an appropriate path, so that the events of the marriage, conduct related or otherwise, can be addressed and will be addressed in a coherent manner.
Thank you.
John, might I just say this on trial presentation, and I can say it because it's not that long ago I was a trial lawyer and I made every mistake, and all the things now I can look back and see that I made all these mistakes. But it is so important as I look back now to see that there must be a theory to your case. I know what I did. I called all the evidence and sort of threw it at the judge and said, you'll be able to figure something out if I can't. And I was afraid to leave any one piece of evidence out. But I was reading an article not too long ago where the author on advocacy said, if you don't know your closing argument before you start the case, it's too late. And it really makes some sense. How many of you feel confident enough to stand up and say to the judge at the opening, this is what I want at the end, and I'm going to show you how I can lead you there? Not many of us ever had that confidence. But if you have a theory to your case, it's so much better than just going in with a shotgun approach and I'll throw all the evidence and maybe some of it will stick. Just a thought.
And it will certainly make for a better debate on the issues at appeal level.
Well, apropos of that, I've heard that there's at least one or two prominent Toronto counsel in criminal law matters in a jury case of any importance have their final address to the jury typed out in front of them verbatim before the trial starts. That's an awful lot of work. And I'm sure in most cases it has to be modified in some respects as the trial goes on. But what it is, of course, is an example of everything having been thought out as thoroughly and as analytically as possible before the trial starts to govern the presentation of that side of the case as the trial progresses, the cross-examination of witnesses and the adducing of your own evidence. So I think that was a good practical point, Tom. Maybe, unless someone would like to say something along this row here, there may be one or two questions from the floor. Yes.
I had a comment, and it was in relation to the qualifications that was raised by one of your panelists. And I think that, of course, the nomination process is important in terms of equality. But as a family law specialist practitioner, every bit as important is to start seeing the bench itself at all levels developing a specialization. And what brings home to me the absence of specialization and the havoc it wreaks for us who are trying to settle cases, not litigate and keep costs down, is when you get an Ontario Court of Appeal issuing two judgments, Robinson and Elliott, which quite frankly for most of us as practitioners don't seem as if they came from the same country. That's one comment, and I'd like to hear whether the bench is far and tall trying to offer specialization. The other is a comment about lengthy judgments, especially from the highest court in the land. The longer you write, the more fodder you get to the academics and the other critics, the more confusion sometimes it can be so to all of us who are trying to make sense and settle cases for our clients. It's very difficult often when you have so many
I'll answer to that.
We were all waiting for something to make your judgment on support, but we're now faced with, and we heard this morning, Carol Rogerson talking about some of the different elements in the Moji case. The one we're left with kind of sort of. So
Well, do you want me to call that a question or a comment? Okay.
Well, I can comment on your comment. I am the culprit in those who write long decisions. I am like that. You have to take me as I am. They put on the bench people who write nothing, and they put on the bench people who write a lot, and that's me. And when you write, when you read professors, I can tell you they write much more than I do. If I read the comments about Moji, for example, Professor McLeod wrote a lot, and so did the others. But my point is that you don't write a lot because you think you want to expand and expand. You write because these issues are before us. And in the Supreme Court, the issues, there are numerous. In Moji, there were a lot of issues, and in Young, there were more issues because there was a constitutional case apart from that. So also, I must say that probably you will hear more about you will have more writing because the context is important, has become important constitutionally and interpretation of law. When you go into the context, then you have to go into legislative context, the social context, it will be long. I mean, Seaboyer and name, whether it was the majority or the minority. What I tell the lawyers, if you don't like it, don't read it, put it in the paper and just put it in the basket and just read the end, the bottom line if you don't. But I think that we talk, I'm talking about this, it's my own opinion and my way of seeing my job. My job is to educate, not only to speak to the parties, but to speak to the public, to speak to the judges, and to speak to the law of the future. So I think that it takes a bit of effort, and don't think that we do it for the pleasure of it. No, it's a lot of work, and it's my style, and I suppose that you have to take me as I am and others as they are. I mean, when Laforet writes in extradition, he writes along judgments because there are explanations to be given, and in doing so, we may muddle the waters, but we may settle a lot of other problems too.
Any more hands? Far corner.
I'd like to comment on the role of child's counsel in custody and access to disputes.
Right. The role of child's counsel in custody and access disputes. Maybe that is more directly related to the trial judges. Tom?
I must say that in the few cases that I've sat on when there's been counsel for the child, I never thought that they played much of a role if counsel for mother and for father were very competent lawyers. I don't think they're needed if they're competent. They may play a role, they may be of some value if it's not an even playing field between counsel. There's also an argument, and I got involved in it, and I'm sure the Court of Appeal will straighten me out, on what is the role of child's counsel. There comes an age when when counsel has to take the instructions of the child. I think the age may be 11 or 12. Under that age, does counsel just act on the basis of what they think is in the best interests of the child? The next question that arises is counsel for the children entitled to give evidence from counsel table? That came up in some matter I wrote on, and it really did concern me that all of a sudden counsel was saying, well, I've talked to the children and they want this, this, and this. The problem was that father had no way to cross-examine that statement. And it would have been so simple for child's counsel to have hired a social worker, could have got the evidence in that way, but they wanted to give the evidence from counsel table. So I look forward to the Court of Appeal giving us some guidance on that matter.
I have a question for Justice Morden on the Elliott case. Do you intend to put Dr. McCabe completely out of work, or is that evidence still admissible to bump arguments regarding duration and quantity?
I'm not going to I'm going to follow, I think, the proper approach. The judgment has to speak for itself on that.
Can I ask a general question then?
It's a free country.
In your opinion, is that type of evidence still admissible to buttress arguments to increase duration and quantum of spousal support?
What specific expert evidence are you talking about? The
Expert evidence respecting lost past income or lost future income of the dependent spouse.
Well, I think it's clear if it's a proper case for a lump sum, reducing to a present value, you've got to have some evidence. As has been pointed out, the discount rate in the rules occupies half the field there. In the old days, you had to call evidence on that too. But I think it's just a matter of common sense. You have to give the court the materials on which to make the calculation and the reasoning process.
And I suppose you can always call the evidence. The question is what value? It may not be of much value.
What value do you think it has?
Well, in certain cases, I think it has some value in what I would call the very true compensatory support case, where the wife claims that she put her husband through medical school. That's a different type of compensatory support. There may be a real reason to call that evidence to show what the value of her contribution was. But then you have to decide what use you make of it.
Well, it looks like we've gone 2 minutes past the hour. Do I turn this back to you, Mr. McDonald, or do I wrap it up?
Well, that speaks eloquently of the thanks that all of you deserve, and I hope that you will join us in the reception that begins now in Convocation Hall. Thank you very much.